And the act of moving onward means we pass these signposts. One of them was first leaving Earth. The next one is hanging out on the moon. What's next? The planets. Onward to the edge. We're moving onward to the edge. Here we are together. This fragile little world. This fragile little world. Onward to the edge. We're moving onward to the edge. Here we are together. This fragile little world.
Hello and welcome to Voices from L5. With me today is Adam Manning, lawyer and space enthusiast who is here talking about space law and how it relates to space settlement. Hey Adam.
Hi Liam, hi there.
It's really great to have you on the show.
I'm very excited to be invited. Thank you very much for having me on.
You're very welcome. One of the original ideas for the show was that I would really love to cover the world of space law. It's such an exciting and new emerging world with all sorts of interesting topics rising up all the time. It's really great to have someone like you on.
Well, that's fine. It's certainly something that's been in the news recently as well, as we'll probably discuss later on.
Oh, that's right. So let's kick off a little bit. Who are you? What do you do? What do you like to talk about? How are you involved in space?
Right. Well, professionally speaking, I'm a litigation lawyer, so I can't say that space law with sadness is something that I deal with on a day-to-day basis in my work. But I'm a space enthusiast, and I'm somebody who's very interested in space settlement and the work, for example, of Dr. O'Neill. Mm-hmm. And I'm part of a group that's studying all these concepts. And I thought it might be useful to use my training and my experience as a lawyer to look at space law in terms of space development and see what the issues are, what the legal issues are around space development, and see if that training and analysis might be of some use in analysing those sorts of issues.
Right. And this is a topic that we've discussed a little bit on the show before about how, there's all these questions that arise when you start extrapolating the way how we currently do things to the way how we'd like to do things in the future. I think one guest brought up the question of what happens when someone lays claim to the first asteroid. How do territory and property laws come into effect in that sort of instance?
Well, that's exactly right. I think really you're getting right at the heart of the issue from a legal perspective. There are two key issues, it seems to me, and those are really the ownership of space resources. So, for example, asteroids, or it might be territory on the moon, or even Mars, for example. And also the utilization of those resources. So, for example, if you have an asteroid, how do you go about the legal ownership of the utilization of the resources of an asteroid, for example? If you produce something from the material of an asteroid, if you make something from it, one of the huge space habitats put forward by Dr. O'Neill, what are the legal issues about the use of those resources as well? So those, to my mind, are the two key legal issues when we look at space development from that perspective.
Right. And I've found that when discussing this sort of thing with some people from the space community, the most often raised solution to these questions is a sort of libertarian viewpoint of if you can get there, then it's yours, and a sort of Wild West analogy that comes up a lot. Is this sort of from your perspective as someone who understands the legal aspects of how things work on Earth a little bit more and has done some research into how it might work in space, how exactly do you see it going about? What is your viewpoint on this subject?
I have to agree with you, Liam. I think that perspective, that sort of libertarian perspective, is something that you come across quite often. And I find that, to be honest with you, a little naive. And that's really perspective of somebody who's not really considered the legal aspects of the situation. Mm. When we're talking about space development, we're talking about very large projects that would involve a lot of infrastructure and a lot of cash, a lot of money to get them going. So the legal perspective, the legal regime that those projects take place in is something that's going to be you are investing large amounts of money, large amounts of effort and material into those sorts of projects. So whatever the law is going to be of key importance to the people behind those projects. And also the other thing to say is that for example, developing asteroids or developing a mine or some sort of facility on the moon, for example, those things, although they're out in space, they don't take place, as it were, in a legal vacuum, and they're going to be people and businesses and organizations who have responsibilities and who have shareholders, for example, very much based back here on Earth, where the rule of law very much does apply. Right. So I think it's going too far to suggest that just because you're you happen to set up a base on the moon, or just because you grab an asteroid and claim ownership of it, for example, that's going to happen outside of the law. I simply don't see that happening.
Right. I mean, that makes, total sense to me. I mean, I've never been a great fan of this strong libertarian viewpoint of space settlement and development at all. I mean, it's like you say, it strikes me as someone who isn't quite thinking it through. Especially the scale that you're talking about. The comparison to the Wild West is often brought up in regards to space development, and I believe John Hickman, our very first episode, mentioned that space development is a lot closer to a project like the Panama Canal, a big, expensive works project that takes decades and eventually allows new forms of trade, and not necessarily just a large span of territory that can go and be claimed for whoever decides it is theirs.
I think that's exactly right. I mean, it was a fascinating interview, by the way, with Dr. Hickman, and I really did like the theme that you developed, which was looking, when you consider these sorts of projects, looking around the whole of the situation and not just considering the sort of science and the engineering perspectives. And I thought that was a very, very strong point that you raised with Dr. Hickman. I think the example of the Panama Canal and that sort of scale of project is going to be the sort of analogy that ought to be drawn. I mean, what we're talking about really is the development of space law itself. Space law really, as we know it now, developed, the sort of principles were developed during the 50s, and then it became really much more embellished and organized during the early 60s. Some initial work was done. It wasn't until 1967 that the first major piece of legislation in this field came into being, and that was something that was developed over time, and the principles were developed over time because it was recognized there had to be some sort of organizational regulation that applied to activities in outer space. As human activity grew and expanded from beyond the Earth, it was recognized that there had to be some form of rules that were agreed for how that activity would be organized. And in particular, the spacefaring nations, and obviously we're talking about the USA and the USSR at the time, recognized that they had a common interest in agreeing some sort of ground rules about how this should proceed. So this whole idea that it's going to be a sort of, I mean, we talk about the Wild West, that the law was very much part of the Wild West because, of course, you've got the figure of the sheriff trying to keep everybody in check. So I'm not even sure that the Wild West was the Wild West in those terms. But as I say, these are going to be mega projects, and they're going to involve such enormous scope of activity that the law really will be very much a key factor. And that's one of the interesting things that's really come out of the work that I've been doing, is in looking at the legal regime for space development and understanding what really are the issues in terms of if you are somebody who wants, perhaps from a private or even perhaps a commercial perspective, to launch a project of space development, for example, exploiting the resources on an asteroid or building a mine on the moon, for example, what are the legal issues? And there certainly are some issues, and it's been a fascinating study looking into all of that.
Well, let's hear a little bit about it. As I understand it, and I am absolutely no space law expert, the treaties that are currently in place that manage this sort of thing, essentially, again, as I understand it, essentially say that space is a sort of humanitarian thing for the people, so to speak.
Yes.
And, no nation who have signed this treaty claims ownership of it as of right now. And as I understand it, that's how the treaty works, and I think the Moon Treaty had a similar sort of tone to it as well. But how does that relate to extrapolating that into the future, when nations do want to sort of start taking, nations and private interests want to start taking control and property of space resources?
Well, you've really hit on the central dilemma, really, for those of us who are interested in space development from a legal perspective. When we look at, for example, the first major piece of legislation is called the Outer Space Treaty from 1967. It has a much longer name in practice, but it's an international item of international law put forward by the United Nations. And this is really what we sometimes call the Magna Carta of space law. And you're absolutely right. The Outer Space Treaty is written from the perspective of viewing space as very much like a wilderness, very much a pristine wilderness that can't be touched.
Almost like a preserve.
That's exactly correct. It's important to remember that the space law is very much influenced by the model of Antarctica. When you've got Antarctica, for example, during the late 50s, the legal regime for Antarctica was put into place. And the thinking there was, with Antarctica, that was very much the last wilderness, the last frontier on Earth, the untouched continent, and that it was important to make sure that it was left that way. So the legal regime of Antarctica wanted to preserve its quality as being a wilderness, as being a pristine wilderness. And the legal regime talks about not having any military bases in Antarctica, and also not really having any great commercial or private development of Antarctica. And it's been very successful in that regard. And I think there's only actually 2 fairly permanent human settlements in Antarctica even today. And that model, really, of viewing space as similar to Antarctica in many ways, is what we have today. And the thinking there is, and you touched on this, is very much that Antarctica, or outer space for that matter, has to be left as a common province of all of humanity. It has to be for the benefit of all of us, and it has to be something that is not sullied or dirtied, if I can put it in these sort of stronger terms, by private or commercial development. It's something that's very much got to be left. So the moon, for example, in this sort of outlook, is a beautiful wilderness, which I suppose it is in some ways, that has to be left and can't really be developed. And the central question is does that, how can we accommodate that approach with the approach that perhaps you and I might be more inclined to think of, which is the development of space and the utilization of space resources to increase space settlement, to encourage and motivate the sort of movement out from Earth of humanity in large numbers. How can those 2 things be accommodated? And that's really the sort of central issue for space law in this area.
Have you reached any conclusions or any answers to that question in your research yet?
That's really the point that I've got to at the moment.
Right.
When the follow-on from the Outer Space Treaty was, as you mentioned before, the Moon Agreement from 1979. Now, the Outer Space Treaty does embody this principle of the common heritage, and it makes it clear that any development, any utilization of space has to be for the benefit of all of humanity. And the Moon Agreement really expounds on that point and makes it much more thoroughgoing. And there's talk about an international regime being set up so that these sorts of issues can be controlled and regulated. And the idea is very much that if a company or a country wants to, for example, use the resources on the moon and set up a mine, for example, if it's perfectly the law is perfectly happy for that to proceed, but the question mark really is over how the products, how the profits even of that enterprise are then put to use. And the idea is, the concept is that if there are any products, if there are any profits, those really have to be put for the benefit of all of us, in accordance with this principle of the common heritage. So it's a difficult point. Now, there's so much that we could talk about in this sort of area. The common heritage principle that I've mentioned is a very profound philosophical perspective. And it's sometimes easy for people who are keen, people such as ourselves who are space enthusiasts who are keen for space development to proceed, to overlook this point and understand the full ramifications of what they're talking about. It's something that was really developed to make sure that problems from the past didn't happen again. So, for example, when we look at the development of America, when European countries colonized America and basically appropriated it for themselves, there was a lot of behind-the-scenes legal justification for what they were doing. And a lot of lawyers at the time, very learned legal scholars, came up with all sorts of theories to justify the appropriation, as it were, of the American continent by the European colonial powers. So the common heritage principle is a modern way of really trying to make sure that never happens again. That this sort of misappropriation, this sort of land grab, as it were, doesn't happen in the future. And this is where this whole philosophy comes from. And clearly, we can all see that must be right in cases such as Antarctica, for example. But the question is that philosophy really something that is appropriate for, say, asteroids, for example?
Right.
Now, asteroids, for example, don't have any particular, or at least it might be possible to argue that particular asteroids don't necessarily have the same cultural relevance or importance that Antarctica has, for example.
Or the moon, even.
Or the moon. Now, we're perhaps dabbling in areas of space ethics here, for example, but it might be possible to argue that at least a lot of the moon, or some of the moon, ought to be preserved in some way because it is culturally important to us. The moon, for example, is always, all the time that there's been humans on the Earth, the moon's always looked, for example, exactly the same. And a lot of people might object, for example, if commercial development of the moon meant that the face of the moon was disfigured in some way, as it were. You can understand perspectives from that point of view. But when it comes down to, for example, building a mine on the moon, which might only have a limited area, for example, or a mass driver, for example, again, if we're talking about an industrial installation that's only of a certain area, well, maybe that's perfectly all right. Maybe the question then is, it is the moon. It's not Antarctica. There's nothing that's living there. It's not part of the Earth, for example. Maybe that would be all right, as long as it's something that is developed in a way that recognizes the importance of the moon culturally to us all. So there are lots of fascinating issues in this area. One important point to make, and we were talking about ownership earlier on, is that space law, and in particular the Outer Space Treaty, makes it very clear that no nation state can claim or appropriate any area of any celestial body, or indeed any particular area of space itself. So, for example, when the Apollo moon landings took place, the American government was very keen, prior to that happening, to proclaim a new law, an American law, to say that just by Neil Armstrong and Buzz Aldrin, for example, planting their flag on the moon, that was not an indication that America was claiming anything of the moon.
Right.
Because they were so disturbed by this point to make sure that they were adhering to the Outer Space Treaty that they felt the need to promulgate new legislation as a result. So it's very important to bear that in mind. And the difficulty with that from the point of view of those of us who are, for example, proponents of space development, is that if nation states cannot claim territory, cannot claim any particular area of land on the moon or Mars or wherever, that means it's impossible really for private individuals or private companies or organizations to do likewise, because private rights to land only come about because of nation states having powers to support claims for land in courts. So, for example, I as a private individual, if I own an area of land, my rights are only recognised because if somebody tries to trespass on my territory, for example, I can go to a court and claim that they're not allowed to do so.
Right.
And that devolves from the nation state having authority over the whole of the nation that I belong to. Mm-hmm. So the theory here is that if nation states are not allowed to claim territory on the moon, for example, then that means it's impossible for private individuals or companies or organizations to do likewise. And in fact, that point is picked up in the Moon Agreement, and in the Moon Agreement, it explicitly rules out anybody from being able to claim territory on the moon or any other celestial body, or indeed free space, as we might call it.
Right.
So, for example, you can't claim a bit of an orbit just for yourself, or you can't claim L5, for example. You couldn't claim a volume of space around the point L5 as belonging to you or your company or organization, as much as you might want to. So, if you're a company or organization that wants to pour in millions because you're very keen on space development and you want to build your own Island 1 space habitat, for example, this is a legal regime that's not necessarily particularly sympathetic to you wanting to do that.
Right. Yeah, I can see that. So, a response that some people would come up with to this would be that space being so voluminous and asteroids being so numerous and even the moon being huge and any potential changes to those objects or installations would take up such little space that the issue of property ownership might not even become a question in the first place. To which I think that I probably am about to default to whatever you're about to say, where that seems a little bit naive to me. You know, I can't see a large company such as SpaceX or what have you not wanting to sort of own the land that they're working on. And as you said, the issue arises of what materials they gain from that land that they have. You know, how does that factor into the idea that they just don't own the land? And so, like you say, it's this question of property is huge, and as much as, you know, like I say, we can hand wave it, it really doesn't seem like something that can just go away. So do you see, this is sort of futurology here a little bit, but is there any precedent for something like this, a situation like this that has been dealt with in a way that we can sort of look at and point to as a way that this might end up going?
Well, I think that's really the sort of $6 million question, as it were. I'm not. When you talk about precedents, for example, there is one peculiar case involving the asteroid Eros that happened a few years ago, and a gentleman had claimed ownership of the asteroid. And when the NASA probe landed on the asteroid, he tried to charge NASA parking fees for doing so. And then when NASA, strangely enough, didn't want to pay, he took them to court, and the court threw the case out as basically a complete non-starter.
Sure.
So that's really the sort of the only effective legal precedent that we have. In terms of precedents, what we can look at is, for example, the law of the deep ocean, the seabed.
Right.
And this is perhaps a more practical precedent. And there, I mean, this is where my studies are taking me at the moment, I have to say. And again, this is a fascinating issue. I've got to say, when we're talking about the commercial or private development of the seabed, I think the general view is that it's been very controversial and very difficult. The law of the seabed has similar principles to the law of outer space that we've discussed. And those efforts that have been made to try and commercially develop the seabed, the ocean floor, have come into a great deal of difficulty because of these points about the legal regime. I'll give you an example about the difficulties that might arise. For example, I've said, we've discussed and we've made it clear that there's no right of property ownership on the moon, for example. And I say the moon because it's the classic example that the space law talks about. And when we say the moon, we mean anything.
Right, we could be talking about asteroids or L5 or what have you at this point.
Or Titan or Pluto or whatever, you know, Alpha Centauri, for example. It's all the same according to space law. It's just convenient just to talk about the moon.
Sure.
One of the implications and one of the provisions of the Outer Space Treaty, for example, is that not only if the Outer Space Treaty and Moon Agreement are quite happy for you to build a base on the moon, or it could be underneath the surface of the moon, for example. The treaties clearly envisage this sort of activity, and they were written at a time around the Apollo moon mission. So this was something that, at the time, that seemed on the cusp of actually happening. Mm-hmm. But one of the little provisions of the Outer Space Treaty is not only do you not own the land that your base is on, if somebody else, if a different country or a different company wants to come in and inspect your base or just have a look around, you have to let them in. And again, that might be problematic for a company who's keen to develop the moon and develop their own products, develop their own techniques, their own ways of working on the moon, for example. Do you really want to have everybody else, for example, your competitors, for example, coming around and knocking on your door? I mean, you have to give reasonable notice. You know, you've got to let people have long enough to brush their hair and wash their teeth, for example, and put the kettle on. But aside from that, they're allowed to come around any time they want.
And which raises a million questions in and of itself, even outside of this specific topic. I mean, the very first thing that I thought of when you brought that up was, you know, you have issues of immigration and other issues like that just spring forth from that single statement.
You know, I'd not thought about that before. That's a very important point. Exactly. So, yeah, I mean, there are potentially political issues because of that principle. So it's more sort of evidence of this not being a legal regime that's particularly helpful to private space development, as I say. And when we're talking about the use of resources, I think the position is even more problematic because it certainly seems that the Moon Agreement, the provisions of the Moon Agreement, for example, envisage people using resources on asteroids or on the moon. And it speaks of the construction of bases on the moon and the construction of things in outer space, for example. So the legislation clearly envisages this happening. But as I said before, it then becomes very difficult in terms of whether you actually own those resources that you produce. And even if you do, even if you have a clear ownership, and I think it's reasonably clear that you are entitled to own things that you make on the moon. So, for example, if we build a base on the moon and we use lunar regolith to do so, the law seems to suggest that you would actually own those materials once you fashioned them into something new.
Sure.
The difficulty comes more in the thorough working through of this principle of the common heritage, the common provision of humanity in what you make and produce in outer space. So it's not, let's say, for example, let's give a crazy example. If, for example, there are mountains of gold on the moon and you wanted to make gold bars from it, it wouldn't be so simple as saying, I've produced these gold bars from this mountain of gold on the moon, therefore these gold bars all belong to me and I can sell them on Earth and make lots of money. The working through of the common heritage principle in the Moon Agreement makes it very difficult to say that it's quite as simple as that, because the products have to be used for the benefit of all of humanity. And the Moon Agreement talks about this in terms of not just those countries and not just those organizations who are actually traveling into space to do these things. It's also got to be with recognition to non-spacefaring nations. So that the whole purpose in enacting the Moon Agreement was very much at the behest of non-spacefaring nations who were very concerned that the spacefaring nations, who of course tended to be the richer and more powerful countries, would be gaining very much an upper hand and continuing their regime of being the most powerful countries on Earth. That would continue to apply in space as well.
Right.
So the Moon Agreement grew out of this concern from the developing world that the sort of power that would be wielded by the spacefaring nations would be something that would yet again keep them on a back heel. And so the Moon Agreement explicitly makes it clear that any products, any utilization of space resources has to be for the benefit of everybody, and in particular it has to recognize the interests and the benefits of the non-spacefaring nations. Now, as I say, this comes back from the profound philosophical context of the common heritage principle itself. But what it does from our perspective as people who on the face of it are keen and supporters of private and commercial space development, it's not something that is particularly, as I say, sympathetic to that activity happening.
So in the future, when these events start happening, when someone starts to try to commercialize the moon or, economize an asteroid and these questions of property start to arise, do you see perhaps amendments to these current treaties coming about? Would that be the solution to this? Or
I think there must be some form of reform that carries on. The Outer Space Treaty, Liam, is so significant that its principles are so profoundly interwoven into space law, into the fabric, into the sort of organizational principles that apply, that it's very difficult to ever see the Outer Space Treaty being entirely repealed, or even if it was entirely repealed, its principles and its approach are still going to be affecting everything. I see this more in terms of working on this international regime that the Moon Agreement talks about, and developing that and trying to recognize the sort of the balance between the common heritage principle, which we can all accept to some degree. We've all got. It must be right that in some ways the common heritage principle has to be respected. I mean, it'd be wonderful if space development was really carried out for the benefit of all of humanity. That would be a wonderful thing to happen. I don't think the reality is going to be quite as simple as that, because it's got to be at some point. It's got to be something that happens for a particular purpose and a particular benefit for particular individuals. But I don't see that the two are entirely in conflict, a complete loggerheads. So my view is that it's really this international regime that the Moon Agreement speaks about that is something that has to be developed and actually analysed. And what I'm looking forward to as my studies continue is really having a good understanding of how that might be, and using, as you mentioned before, the precedents that we have before us as well, and seeing what lessons can be learned. One thing that you've got to bear in mind is that the Outer Space Treaty has actually been ratified by a large number of countries.
Sure.
And by all the spacefaring nations, whereas the Moon Agreement is in some ways considered to be a failed treaty because only a limited number of countries have actually ratified it. I think by May 2014, it had only been ratified by 16 states. And I think one of them in particular, Australia, wanted to withdraw from it. So it's not been entirely successful. But I think it's still important. It's very important, in fact, because what it does is it gives us an understanding of how the common heritage principle that's talked about in the Outer Space Treaty can be expanded upon and embellished into actual provisions. And it's really disappointing in some ways that the Moon Agreement wasn't ratified more fully, because that would have developed this idea of the international regime more, and we might actually by now have a fully fledged regime run presumably by the United Nations that helps us understand how these things work.
Right, yeah, I mean, that would be, I think, especially with people like myself who sort of still see nation-states being vitally important in space development. The new space revolution that's coming about is sort of leading a lot of people to stop caring so much about what nations are doing in space and care a lot more about Boeing and SpaceX and planetary resources.
Yes.
Personally, I still see NASA and, the British Interplanetary Society and, all of the other China's space program. I see those as still incredibly powerful and still doing incredible things and still very much at the forefront of what we do in space. And I think that ultimately what I and people who see the space race, I suppose, in the way that I do, as an ultimate goal would be a UN, a sub part of the UN being used to discuss these sort of issues and deal with the space law. And it's interesting to hear about this international regime that's mentioned in the Moon Treaty, because that sounds exactly like the sort of sovereignty thing that, again, Dr. John Hickman was talking about in the first episode.
Yeah.
A group specifically for doling out land to groups that may build things and produce things that are for this common heritage sort of concept.
Yes.
Which is the common heritage thing, which you keep bringing up, is very interesting to me, because a lot of the space projects that we talk about, that we want to develop space for, I can see being very easily justified for this common heritage. I mean, the main one that we always talk about is solar power, and the infinite amount of solar power that we'd be able to draw in 24/7 using space resources, which would be, I mean, arguably for the benefit of all mankind. It would be a great deal of energy, and it would power a great deal of the world if the people who built it desired it to be so. And one of the concerns that I've always had about that sort of area, and especially with private interests getting involved in space development, is that a privately developed space solar array, I've always been concerned, would be for the rich countries. So I saw SpaceX. I saw a future where SpaceX would develop a solar array and then use that to provide cheap power for America. And it's interesting to hear that when we were going to the moon, people already foresaw those issues and set forth this framework that may, in some ways, protect or prevent that sort of behavior.
Yeah, I think that's a very important point. I think you're absolutely right in terms of the nation states being the most powerful in terms of these sorts of very large-scale projects. And really, the nation states are going to be the ones who are going to have to work out this international regime. And these space laws, we have to remember, came about because of the relationships of the nation states themselves. So the Outer Space Treaty, for example, is very much a product of the early Cold War and the relationship between the US and the USSR. And the Moon Agreement is much more to do with the relationship between the nation states of the developing world and the spacefaring nations. So I think that's exactly right. And I think you're right to say that the international regime is something that will be a focus for the relationships between the nation states as well. What I do think as well is that at some point it's going to have to be reformed if we're going to get somewhere, because my concern is that I do accept what you say, that these sorts of large-scale projects, if you look at them in the whole, if you look at them from the outside, all of them are very much for the benefit of humanity. So, for example, space-based solar power, that's such a wonderful concept. If that was to actually take hold, that could revolutionize everything. It could thwart global warming, or at least be part of a program to deal with global warming, global climate change. It could revolutionize energy use and energy production throughout the world. So on the outside, that is something that is very much for the benefit of the whole of humanity. And mining the moon and the resources for the moon, again, if you look at it in the round, very much for the benefit of humanity. My concern is more that if you look at any particular project, as you say, for example, if you imagine, Elon Musk, you're talking about SpaceX producing solar power, for example, from space. It turns out, in point of fact, Elon Musk is very much against it. He doesn't think it's actually going to work, from what I read in the newspapers. In any case, if you're looking at any particular project like that, the difficulty is that the application of the common heritage principle, particularly as expounded on in the Moon Agreement, suggests that is not something that would be of benefit to all of us, because it's such a defined project, because it's a particular application. It's something that the developing world, who were the people, who were the countries that were behind the drawing up of the Moon Agreement, they could use those principles to create a hostile environment for a private project like that to really work in.
I see.
I think that's really the concern.
Well, what would a project be that does adhere to these principles?
Well, I mean that.
Could you build us some sort of loose example?
You do have to wonder what exactly the Moon Agreement has in mind with a project that would tick all these boxes. I think it will be something real. I think what they're really getting at, if the prime example of a project that would be something that would adhere to all these policies, is very much an international space project. So, for example, you could even see the International Space Station as something that adheres to all these sorts of things. Or some sort of multinational project. If there was some sort of multinational project that was truly internationalist in its scope, that was looking at solar power from space, or the use of the resources on the moon, for example, that might be something, or a large space habitat on L5, that might be something that could adhere to all these policies. And I think if that were to happen, I think that could very well be a fantastically ideal project.
Right. And I mean, that is, in a lot of ways, what Dr. O'Neill, I feel he envisaged in the book High Frontier.
Yeah.
But it's interesting to hear that space, that even something so, helpful to everyone as space solar might not even tick those boxes. One topic that I do want to talk about before we quite run out of time is, I think that some people look at treaties like this, and who may not be in the know, and see them as slightly toothless, and can't quite imagine how they play into how the world works, and how, actual companies and actual nations go about their projects in space. But it was interesting earlier that you talked about how the application of one of these treaties made life pretty difficult in at least one instance. And I guess my question would be, hypothetically speaking, if, just to pick a name out of the hat, as SpaceX decided to do something that wasn't applicable to some of these treaties, what would be the repercussions for them, if any?
Well, that's an interesting point. And in point of fact, it's very current at the moment. I don't know if you're aware of this, but the Federal Aviation Administration in the USA has recently given a pronouncement that it supports a request by Bigelow to have approval, in sort of round terms, for commercial operations on the moon. And the Federal Aviation Administration has announced that it will support any attempt or effort by Bigelow to bring about commercial development on the moon. Now, what's interesting about that is that in the sort of articles that you read on this subject, it makes it clear that whilst the FAA, which is a government authority in the USA, recognizes that it has the power to not necessarily give licenses to operate on the moon, but it does have power to authorize and encourage and support American organizations and American companies from carrying out commercial operations on the moon. But at the same time, what it does recognize is that there is this problematic international context in which these operations take effect. So when it comes to, when you're talking about a company, and you mentioned the example of SpaceX, let's talk about SpaceZ to avoid a real company. If we talk about SpaceZ, a private company based in Britain, let's say, for example, if SpaceZ suddenly wanted to do something that would be in clear breach of these sorts of principles set out in these treaties, the difficulty there is that there's an obligation on national authorities to license activities in space carried out by their own nationals. So, for example, if I want to launch something from England into space, I have to get a license from the UK government through the Outer Space Act. And the reason for that is the Outer Space Treaty makes all nation states responsible for activities in space carried out by their own nationals. Right. So that's where this obligation on countries comes from to license activities that are carried out in space. Now, it's very interesting, therefore, that the FAA were quite happy to give not a formal license as such, but give their support to Bigelow in saying that they wanted to carry out commercial operations on the moon. If it was clear, I would suggest to the national authorities here in the UK that our company, SpaceZ, was going to do something that really did breach the Outer Space Treaty and Moon Agreement on the moon, then they would simply not license it. And the company would not, in this example, have the authority to launch from the UK and carry out space activities. So the whole thing would become a criminal activity. So that really would be the power that the nation states have to control these sorts of activities and ensure that they are in compliance with the Outer Space Treaty. It's more problematic with the Moon Agreement because, as I say, it's not been ratified enough. It's not been ratified widely enough for it to be enforceable. But certainly, if there was something that if a company was clearly going to carry out activities that were in breach of the Outer Space Treaty, then it would be beholden on that nation state not to license them to do so.
Well, I think that's about what we've got time for now. Is there any projects you'd like to plug before we sign off?
Well, it's very kind of you to put it that way, Liam. What I ought to say is that my interest in space law and these sorts of specific issues is also very much fired up by the fact that I'm a member of the British Interplanetary Society and I'm partner of what's called Project Space, which is a wonderful project where we're looking into the studies by Dr. O'Neill and his colleagues from the 70s into space habitats, the habitats of Island 1, Island 2 and Island 3. And we're looking at those studies and seeing really how could they be updated? What are the lessons that we've learned since those studies were carried out? And what are the issues today? And also, in accordance with the sort of concept that you and Dr. Hickman were discussing on your podcast, looking around not just at the engineering and scientific issues, but looking at the broader humanitarian perspective, the broader sort of political aspect. And there is so much to look into, and it's a really fascinating study project. So anybody who's interested in L5 and space habitats, I'd strongly recommend that you have a look into what we're up to, because it's great fun and we're learning a great deal from doing so.
We may have something special lined up for people who are interested fairly soon on that subject, actually. Little hint, little sneaky hint there to some future episodes. I do want to say quick before we go, thanks for the suggestion for SpaceZ. I'll be using that in the future for future examples. I have terrifying nightmares of Elon Musk shaking his fist at me behind his computer. He comes up in every single example for terrible companies doing horrible things in space, and that can't be healthy for my future.
I think he's a fantastic character from our age, and he's a leading light in these sorts of things in many ways. And we should be very grateful that we've got a character like him who's trying to push these things forward.
I certainly think that space needs more people like Musk doing the things that Musk does and doing all of the interesting things that SpaceX is doing. 100%.
Yep.
I'm saying that to you directly, Elon. Please, we should be friends.
We should all have his money and be able to do what he does.
That would be great. That would be fantastic. So you've been great, Adam. And this has been a fantastic show. I've a lot to think about here. Like I said right at the beginning, space law is just this. It's just an amazing. It's a question that once you ask it, asks a million other questions. You know, every statement that you've said today.
If you've enjoyed this segment, please check out John Hickman's article, The Political Economics of Very Large Space Projects, as well as his other material. If you have any comments or suggestions for the show, please email me at voicesfroml5@gmail.com or leave a comment.
Thank you again.
Music for Voices from L5 has been graciously provided by John Boswell of Symphony of Science. Find more of his work at www.symphonyofscience.com. Hey, if you like what we do here and you want to hear more experts from all sorts of fields talking about space settlement in ways that you might not hear anywhere else, consider donating to our Patreon account. We really rely on donations to keep the show going, and even a small donation helps us get better guests, better equipment, and produce a better show for you. We have some great goals in mind for the show, and we'd really like to make something special. You can check out a link to our Patreon account on the website, or in the comments or links that accompany this show. Thanks.